Good morning, good afternoon, and welcome to today's webinar, the EU Forced Labour Regulation and the EU Corporate Sustainability Due Diligence Directive. How do they work together? My name is Valentina Bolognesi. I'm Advocacy and Engagement Advisor at Amfori, and it is really my pleasure to welcome you today to this webinar, which is jointly organized by Amfori and the Partnership for Sustainable Textiles with the support of the German Helpdesk on Business and Human Rights. Today's webinar is part of a series of webinars on due diligence laws in practice that we have been jointly organizing with the German PST and the German Helpdesk on Business and Human Rights, where we unpack aspects of emerging due diligence laws, but we always also try to offer some practical insights and perspectives into how companies and collaborative initiatives such as Amfori and the German Partnership for Sustainable Textiles are supporting companies with operationalizing aspects of their due diligence. So you're most welcome also to go back to the recordings of this webinar. And today's webinar will be indeed about the forced labor regulation and the CSDDD. In terms of housekeeping rules, you are all muted, and this is to ensure a smooth functioning of the webinar. Nevertheless, we do encourage you to engage with us through the Q&A functionality by posting your questions throughout the whole duration of the webinar. We're gonna foresee two dedicated Q&A sessions, and we will do our utmost to get to your questions either orally or in writing. But to manage expectations, we have noticed from the past that we oftentimes do not manage actually to get to all of them. Therefore, we do apologize already in advance in case we cannot address your questions. The webinar is being recorded, and the recording alongside the slides will be shared after the webinar. We're also, as always, going to share a quick satisfaction survey, and the idea is for you to kindly tell us what you thought of the webinar so that we can improve going forward. Quickly taking a look at the agenda for today, I will provide some introductory remarks, and then I will hand over to Johannes Maximilian van Lingen from the German Helpdesk on Business and Human Rights. We're very happy to have him. He will be the one actually unpacking the EU Forced Labour Regulation, but also talk as to how that fits within the wider due diligence framework, and then handing over to my colleague Stuart Newman, who is also an expert on the forced labor regulation. He will be moderating the first Q&A session, which is therefore geared towards the forced labor regulation as such. And then we're going to move practical into listening to colleagues Jonathan and Alessandra from Amfori, Jonathan Thorngreen and Alessandra Tranquilli from Amfori. They will set the scene as to the Amfori system and how that basically supports companies with forced labor due diligence. And then we're going to have Caroline Knospe from Zwilling, a member of Amfori. She will share with us a practical example as to how Zwilling went about identifying a forced labor case and then working with the business partner to remediate. It will be then the turn of Melina Kunde from the Partnership for Sustainable Textiles, offering an overview of the PST tools and programs, and then some Q&A, again, another Q&A with some closing remarks. If we could move on to the next one, please. Just setting the scene in terms of forced labor, not knowing about the audience that we're going to be having today in the room, we thought that it would be important just to also be reminded of the latest global figures when we talk about forced labor. According to the 2022 global estimates of modern slavery, forced labor and forced marriage, there are some 28 million people found in forced labor globally. Of those, nearly 12 million are women and girls, and of the total of people found in forced labor, more than 3.3 million are children. If we compare the 2022 global estimates with previous estimates, I think we quickly come to the conclusion that forced labor has grown in recent years, and there is no region of the world that is spared from forced labor. In terms of where most cases are found, it is actually in the private economy, with sectors such as construction, manufacturing, and the domestic work that are the most affected. Though I think also in other sectors, it is clear that forced labor is found. In terms of workers, those that are migrant workers face a higher risk of forced labor compared to other workers. If we could move to the next slide, please. When we talk about forced labor, it is actually the definition of it is found in ILO Convention 29, where forced labor is defined as the work and the service that is exacted from any person under the menace of penalty, and for which that said person has not offered himself or herself voluntarily. Therefore, we're talking about work and service under the menace of penalty that is performed not voluntarily. The ILO has also established 11 indicators of forced labor. Those are to be regarded as operational indicators to support operators that are in the look for forced labor to identify instances of forced labors. Therefore, they should be regarded as sort of red flags. In the interest of time, we're not going to extensively go through them, but just to outline, for instance, the debt bondage, that is the case of workers having to work to pay back basically a debt that they have accumulated, for instance, through the payment of recruitment fees. And I want to just highlight this because it's linked to the case that will be presented by Caroline from Zwilling. And if we could move to the next slide, please. I also just wanted to very briefly outline that the ILO has worked on a definition of recruitment fees and related costs. This is because there are risks of exploitation throughout the recruitment process, in particular when it comes to migrant workers. And the high payment of recruitment fees can actually result in workers being found in a situation of debt bondage. So the payment of recruitment fees actually should not occur, and according to the ILO, no workers should be charged directly or indirectly for the payment of recruitment fees or related costs. The last slide, I believe, before handing over to Johannes, is really just to very briefly outline the connection, or the nexus rather, between the Corporate Sustainability Due Diligence Directive, which we have been unpacking in previous webinars, which entered into force in July this year. It's a company level framework legislation that will start to apply to certain companies as of 2027, and it stipulates a duty on EU and very large, I should say, EU and non-EU businesses above certain thresholds to conduct due diligence to identify and manage risks of negative impacts, including, for instance, risks of forced labor. So forced labor features also somehow within the framework of the Corporate Sustainability Due Diligence Directive as a risk that needs to be managed by businesses. The EU forced labor regulation, which will be the topic of Johannes' presentation in a minute, is a product-based instrument. Actually, it applies to products as opposed to companies, as it is the case of the Corporate Sustainability Due Diligence Directive, and it stipulates that products found to have been made with forced labor should be banned from the placing on, the import, and the export from the EU. So what I'm trying to say is that the due diligence is the expectation, underlying expectation, that companies perform due diligence to identify, manage, remediate risks of, amongst others, forced labor. But when forced labor is found in a product, then the forced labor regulation foresees basically a ban on those products. That's all I wanted to cover in terms of introductory remarks, and then I'm very happy that we have Johannes Maximilian, who is joining us actually from the US. So thank you so much for still making the time to be with us, and we very much look forward to your intervention now. And please do ask questions while Johannes actually intervenes. Thank you.
Thank you so very much. Thanks a lot for the invitation and the opportunity to speak here today on the forced labor regulation. As you probably know from previous events with the help desk, who are we? We are the German Helpdesk on Business and Human Rights. We are an offer by the German federal government to help companies with the implementation of human rights due diligence processes. I'm specialized on forced labor, especially in regards to human rights due diligence in China. what we do is that we offer free of charge consultations for companies and do it confidentially and try to be a partner for companies and other actors when it comes to the implementation. What we do besides the consultations, and maybe next slide, please, is that we also provide a range and with different partners of tools. I have listed the Business and Human Rights Navigator here because when we talk about forced labor, of course, a lot of companies and other actors ask us if we have some cases or examples, even best practice examples of companies dealing with certain human rights violations. And what you see here, the Business and Human Rights Navigator, you will have also the category of forced labor. You will find a lot of information on the topic, on the legal framework, but also on best practice examples, how other companies deal with the forced labor issue in their supply chain. So I just wanted to quickly highlight that, and you can also find the link there if you're interested in looking up best practices. So what I'm going to be talking about today, of course, is the forced labor regulation. And probably a lot of you have heard about the big step that had to happen yesterday, which is also why I had to change the slides up just last minute. What happened yesterday, of course, was that we're here now when we look at the 2024 that we have a final text agreement between the Parliament and the Council. So when we go back, of course, a lot of people probably know that the EU forced labor regulation has been long in the making. Of course, there have been political intentions. And I just wanted to give you a short overview with this slide on the background and also where we are going with the forced labor regulation. We see that we have the end of the trilogue process between Parliament, Council, and Commission. We see that, and I was made aware of that a couple of times by now, that the regulation will enter into force after the publication of the official journal. The current state of the forced labor regulation, as I assume is right, is that we have the agreement, but we are missing the signature of the President of the Parliament and Council, I believe. And after that, one day after the publication in the official journal, the regulation enters into force, which, of course, I believe this step wasn't, with the signature wasn't done yet. So I still have the estimated in, but of course, as mentioned also, I see in the discussion, it was adopted yesterday. So what we have then, we have 36 months, three years of until full application of the regulation. But also we have within the regulation and the final adopted text certain aspects of the regulation that is also has to be implemented prior to that. This is, if I see it correctly, mostly in regards to the commitment by the member states, for example, that they will have to find a competent authority or designate a competent authority within a certain legal time frame. So this will also mean that we have here the estimated transition period by the member states. There will be a lot of interesting, important steps happening so that the regulation and the Commission and the member states actually are prepared and help in regards to the implementation of the regulation. We see it, for example, and I will go more into detail on the forced labor risk database, which will probably be a big point of discussion and help for companies. Of course, also guidelines and risk indicators. And then after the 36 months, which then will be calculated when that exactly will be, but 2027 seems reasonable as far as I'm aware. The regulation will be fully applicable. And also the enforcement, of course, and investigation might start at that point. Okay, next slide. So what we have also, Valentina already highlighted the core of the forced labor regulation, and that is that it's product-based. Of course, we are all, I assume, all in the world of business and human rights. We all deal with human rights due diligence, and there's certainly aspects of it also within this regulation. But the huge difference, of course, is that this regulation stipulates a form of prohibition. It stipulates a ban on certain products made with forced labor. To put it simply, of course, it's not the 100% correct legal term, but it doesn't attach itself to the process within the company, but rather is linked to traditional import ban regulation that we see also in other places of the world. So also the intention of the law, of course, was different than, for example, when we look at due diligence legislation, which attaches itself to a sort of best effort principle, so that the companies have to perform in a manner that shows a certain amount of effort to then fulfill obligation. What we have with forced labor regulation, which is based on the circulation of the product, it's the prohibition of that. So there's two different kind of regulations, and the forced labor ban, of course, to put it simply, in that case, is considered to be then the more severe intervention, the more severe law when it comes to this particular human right. What we see in the scope that, of course, and there's also the big difference, and we see it applies to all products, domestic and imported. We have all sectors and product stages covered, even though there is exclusion included in the final text for transport services, if I'm correct. And it also includes distance sale. This was also added later. So what you probably can imagine when products from anywhere in the world are also offered to EU customers, is also should be included, even though that company might not have an operation or website based in the EU. And the key feature, of course, is the definition of forced labor also by the ILO. And what is actually the bulk of the regulation is the exact frame setting and enforcement competences by the authorities. So to give you like a feeling of the EU forced labor regulations, you will find that the actual obligation to not put the products made with forced labor on the market or make it available on the market is quite short, and the bulk of the regulation is on details about the investigation or the authorities. And I will try to focus a bit on the company side of it, but nevertheless, of course, also the investigation processes are nevertheless very important. Next slide, please. Right. We have heard already the definition of forced labor, so I will not repeat it. Of course, it attaches itself to the ILO definition. We have, however, added a couple of exclusions also within the new text of the forced labor regulation. We see that we have certain exclusions. For example, I don't know if I actually mentioned them when it comes to strategic sectors that are important to infrastructure, for example, where it might not be reasonable. We see other exclusion, as I've mentioned here, compulsory military service, normal civic obligations, court convictions, case of emergency, I think that's the one I mentioned, and minor communal services. We have that added as well. And also the ILO indicators are mentioned also in the forced labor regulation. So to again give you a feeling of the forced labor regulation, the core of the definitions and the core of the provision of the products made with forced labor are really rooted in the ILO definitions, which can be used in that case, and the exclusions are also mentioned there. Next slide, please. We have, of course, I already mentioned that all products are included, also components. We see that of course, the forced labor regulation wants to tackle the forced labor in an efficient manner. That also means that we don't see the product only as a whole, and the components are regarded as such. No, also the components made with forced labor who are attached or risk to having forced labor within them are also included within the EU forced labor regulation. We also don't have a limitation on the sector or region for a certain country or a certain industry. We also don't have the distinction between whether it's domestic or imported. And what is also important to see, the forced labor regulation doesn't distinguish where the forced labor occurred in the supply chain. There's certain consideration when it comes to the investigation within the forced labor regulation that might allow the authorities to prioritize actors who are closer to the violation. However, when it comes to this part of the regulation, we see that any stage within the production or manufacture, harvest or extraction of the product will be considered under the forced labor regulation. There's no such distinction or prioritization in that case. And the most important activities under the forced labor regulations, we see here what is actually the behavior that leads to a certain ban. This is those three. We see them here. We see placing on the EU market. It means that the first time it gets entered into the EU market and making it available on the EU market as well. So, and then exporting from the EU. Those are the behaviors that are attached to so-called economic operators. Those are the subjects of the EU forced labor regulation, which sounds a bit unfamiliar, at least to me, but it includes more than just companies. The economic operators under the forced labor regulation also means a legal person who have such conduct such market activity, such as placing products on the EU market. So they're all included. Next slide, please. Oh, they're set to the economic operators. I mentioned that already. We see also, I mentioned the sales over distance. When we, for example, over an online platform, we buy a lot of products which from a company who doesn't sit in the EU, but actually targets EU customers, and it is also included. And we have the exemption of the transport services. What is very important, which is one of the core aspects of the enforcement in the forced labor regulation is the risk-based approach by the competent authorities. Of course, we know that from the German Supply Chain Act, we know that from the CSDDD, which also wants to stipulate the risk-based approach within the enforcement of the forced labor ban. And we have a distinction, of course, this has various reasons, but we have the distinction that the competent authority, the lead authority, will be split when it comes to the non-EU cases. Then it will be the EU Commission. When it's EU cases, it will be the respective national authority. And of course, under the EU law and also under the, of course, forced labor regulation, the decision made by one EU member state, and this should be clear, will also apply and have to be respected by the other EU member states. Next slide, please. Of course, what we are all looking forward to are the guidances and the support measures established by the EU Commission and other actors. What we see here, and this is only one part of it, and it will, I assume, have huge practical implications also for the execution of this forced labor ban, is of course the forced labor risk database, which will be established by the European Commission. It will be publicly available, and it will be, of course, a non-exhaustive list, and will be updated. And we have then hopefully a database which will have data based on information that the European Commission received. It might include information from government, civil society, if necessary. So there should be a lot of consultations happening at some stage later. And the intention, of course, is that this risk database, of course, also can be used by supervising authorities or the authorities conducting the inspections. But it also can be used, of course, for companies to have an indication on what actual forced labor risks look like, especially SME. And it should cover all sectors and several regions globally. I will assume that it will be expanded on over time. And the last aspect, the usage I mentioned already. So maybe we can do the next slide. What we see, which was also one of the big discussion points, was the support for SMEs. We, of course, have a huge list of guidelines that are supposed to be published by the European Commission on the forced labor regulation. And I mean, if you look into it, I think it's, I don't know, 8 or 9, I'm not sure if that's correct, but guidances. And of course, they also want to tackle the aspect of how do we do this in practice. It sounds very complicated. And some of the guidelines, of course, are specially designed for SMEs. And what we also see that the regulation wants the member state to designate so-called contact points for SMEs to help them. Contact points, or I think also in the regulation is mentioned also help desk, so that might be a future development at some point, and also under resources to help the SMEs with the implementation, because we have seen the scope of the regulation doesn't distinguish between SME or big company or natural person. It's attached to the market activity. So the regulation also had a lot of aspects in the end added to help SMEs in regards to the implementation of this regulation. For example, we not only have this within the guidelines, But we also see, when it comes to the detailed paragraphs for the investigation for the authorities, that there are several aspects actually considering as SMEs, for example, that the size and resources are to be considered when it comes to certain aspects of the preliminary investigations. So you will find it throughout the regulation, and this is one of the aspects from the regulation that supports SMEs in that regard. Next slide. So I've drawn a little. It's not very pretty. I must apologize, because we don't have like proper graphics yet. But I just wanted to write down a short process that might occur under the forced labor regulation, and what we can assume what this regulation actually means. So we have the process of that the competent authority has to take the first step based on the risk indicators. This might be different to other regulation we know in the world that has a change of burden of proof. So that, for example, companies will have to prove that the products made are without forced labor. When we look at the forced labor regulation on the EU level, we have the first step from the competent authority. And this is also very crucial to their understanding, I believe. So the competent authority might then ask the company X about the supply chain. And what is very, very interesting, and it's also more detailed, and I think we're also going to hear from it today more, the information that are requested are hugely linked to obligations to human rights due diligence, not only obligation, but also voluntary standards. So when we look at the forced labor regulation, which is not a due diligence obligation regulation in that sense, there was even a clause added in the end that actually excludes it explicitly, that there are no due diligence obligation established by this regulation. However, when we look at the information that can be requested by the authority onto the company, it actually includes the information on how well does the company conduct the human rights due diligence, to put it very, very simply. And then we have the company response, and under the regulation, also the response and how the company works with the authority, if it's good or bad, or if there are false information or not, if it's collaborative, also may have an impact on the decisions later down the process. And the company will provide those informations then, and can provide the aspects of the due diligence efforts, and if they have taken corrective action. And then within different time frames, of course, I haven't added all the dates here, the authority then can examine the evidence, and also use a already mentioned forced labor risk database, and can also, if it's helpful, conduct on-site inspection. Then after time, the authority will, of course, have to decide on the case if forced labor is found, and then the products and the authority will have to prohibit the products from the EU market. If not, of course, the case will be closed. And the enforcement in the end looks like that the products have to be withdrawn from the market and stopped at customs. And very interesting, it might even mean the destruction of the products, or when possible, also recycling of the products. And then the company, of course, has the obligation to comply with that. We also have added a mechanism of appeal and remediation that the company, of course, can appeal to the decision made by the competent authority. I just drew this short process here to give you a feeling of how this regulation is intended. Of course, we see the first step again, the competent authority action, and then the response by the company to give you a sense of how this regulation is intended to work. Next slide, please. Yeah, I already mentioned, probably everyone in this webinar today knows that even though the regulation isn't intended as a due diligence regulation, we all know that the processes within the company are all based within the same department, within the same processes. And we see that when we, for example, conduct human rights due diligence, sustainability department, of course, also the aspect of forced labor will be considered and therefore in the end integrated within the whole process. So I just wanted to highlight this aspect, and I'm happy and looking forward to hearing more about this. Maybe the last slide, I believe, is one of the last slides, which I just wanted to, I would not repeat and recite all those aspects here, but just maybe as first steps for the preparation when it comes to the forced labor regulation, I wanted to include this. And also, of course, we're going to share the slides afterwards. What we discussed already, that we, when it comes to the good preparation and first steps for the forced labor regulation, it is important to distinguish the aspects of human rights due diligence obligations and this provision of products made with forced labor. And within the company, of course, use those resources already existing, meaning risk analysts and I called it the cross-department integration. So if you have people and designate people who are responsible for this regulation or for only forced labor, this will help tremendously also to engage with the different departments. We see, of course, a distinction, and this also distinguished in the regulation on special challenges when it comes to state-imposed forced labor. And this maybe as a last step, because I'm already over time. Of course, it will be a topic also within the company. So one of the preparation steps I would suggest in that case is to develop a strategy when it comes to especially state-imposed forced labor, because the approach you might want to find within the normal human rights due diligence forced labor aspect might not work on forced labor, and might even show itself as a hugely complex issue that can't be leveraged or helped that easily. So just a couple of aspects, of course, they're much more, and it's much more complex than just those bullets. But I think I will stop here. Maybe we can do the next slide. I think that's the last one. I hope I could explain the forced labor regulation a tiny bit. Of course, it's much more complicated, but thank you so much for listening.
Thank you so much, Johannes, for taking up the challenge of telling us all we need to know about the forced labor regulation in such a short amount of time. We have received very many questions, and I want to pass on another challenge to my colleague Stuart to pick and choose some of the perhaps most significant questions to then pass on to Johannes. Over to you, Stuart.
Yes, thank you. As you say, we have had many questions, some of which have already been answered live by Johannes, I think, as he was speaking, a few of which I've answered directly in the chat, but that still leaves quite a number. Let's start with the very first one, actually, that came from Liana Steinbeck, who said, and she mentions that in the explanatory memorandum, the economic operators has to provide evidence that forced labor is eliminated from the supply chain, and change in suppliers cannot be considered a way of eliminating the forced labor. So what are companies supposed to do if the business partner is not collaborative? And how does that align with the CSDDD? And then there was another question further down that also said, what do you do if your business partner isn't helping you out? Johannes, do you want to respond to that?
Well, that's the biggest dilemma, right? We have this dilemma, and we already mentioned especially the dilemma of best effort. regulation we see within the CSDDD, and then a prohibition and a ban of products. So that's exactly the dilemma. What we actually see within the forced labor regulation, that there are efforts made to not have a conflict of interest in that regards to the CSDDD. And we see it within the forced labor regulation. We see it in almost every step of the investigation, that there are efforts made. I don't know how it's going to be in practice, to be honest. For example, we see that the FLR wants to regulate that the efforts made within this human rights due diligence obligation, like the CSDDD, are not a disadvantage and not used to make a negative decision on the FLR. But of course, those regulations and those phrases within the FLR will have to be seen how it will be executed in the end. And when it comes to the doability of the implementation or the change of suppliers or exiting certain markets, I always was told, well, that's a ban, that's a prohibition by the intention of the regulation. So the intention is a hugely different one than the CSDDD, where we have the effort as the standard of the fulfillment of obligation. So I know the dilemma, and there are certain aspects that we could go into at another point when it comes to the more detailed consideration of other due diligence efforts. Yeah.
There's another couple of questions. One, both related. One is on what level of traceability will be required, and another one mentions must we ensure traceability to raw material extraction, similar, for example, to the battery regulation and the EU DR. That's quite a quick one to answer, I think, Johannes.
Yeah, maybe you want to answer, because yes, of course, it's included. As I said already, the forced labor regulation attaches itself to no certain stage of the product. So it might be any aspect of the component on the product. And of course, the traceability is hugely important. Well, we all know this for the CSDDD. We all know this also then for forced labor. What we see, the forced labor regulation doesn't tell you exactly how you have to trace those informations. It doesn't tell you that you have to do it in a reasonable manner. It doesn't tell you that you have to do it within best effort. But what it does in the end, if the competent authority in the end finds, in accordance to the risk indicators, forced labor risk, and might even find that the product is made with forced labor, you will have to prove otherwise. So the traceability in that regard is not a so-called legal obligation under the forced labor regulation, but it will be hugely important to actually addressing forced labor problems in regards to this regulation.
That actually, and you just also answered the second question about who has to prove the forced labor. There's another interesting question here on distance sales companies. For example, those in Asia, how will they be sanctioned if they sell products directly to the EU?
Well, the sanction mechanism, of course, is then the withholding the product. So when the product is deemed to be made with forced labor, then of course the product in the end is not to be imported in the European Union. So the custom authority from the respective countries are not allowed to let it go through anymore. That's basically the principle.
Someone else is asking about whether the Commission will issue a list of geographic regions where the presumption of forced labor applies. I mean, that will basically be part of the database, which will, as Johannes mentioned, will be publicly available and also used by all competent authorities. One, I think, has been answered live on the providing proof. Here is a procedural one. How much time does a company have to respond to the requests from the authority?
Oh, I don't have the exact time frame open. I believe it's 1 month, and especially considering SMEs, it might even be longer. I think they've even included a phrase for helping the SMEs where it says, in accordance to the resources, it might even be longer. But I will have to look into it. Also, it will be very interesting. I haven't done it yet to do a proper time frame, how long the process will actually be taking. So this is to consider. I believe it's 1 month, but please look into the regulation once again. And yeah.
Yeah, maybe I jump in on that point then. So prior to the actual investigation, the economic operators will be asked by the EU what due diligence efforts they have already made, and they will have 30 days, indeed 30 days, to respond to that. Once the investigation is open, again, there is a 30 days for the receipt of information provided by economic operators. So at least 30 days, or no longer than 60 days. I believe that's why the slight extension that Johannes was speaking on. Okay, let me just see if there are a few more, because there's still more questions coming in. Let me just see. Okay. How much time do we have left before we move on to the next section? Because we have so many questions here.
Yes, maybe 3 more minutes, I would say, Stuart. I know.
Yeah.
So just select a few more, and then we can try to answer them in writing as much as possible.
Okay, and then somebody
Thank
here is
you.
saying, although it is a regulation, we will still need an implementation of the regulation in the member states. I mean, the regulation will apply basically across the member states, but each member state will have to set up its own competent authority to deal with accusations of forced labor within the EU, and then the Commission will deal with investigations outside the EU, as Johannes said.
Maybe just to distinguish it for the people who don't know, when it comes, for example, to directives like the CSDDD, of course, you have the implementation into national law after 2 years. And we don't have this with the forced labor regulation. It applies and gets into force directly.
And finally, perhaps one has said, if forced labor is found, but the company has provided remedy, would the authorities open or continue to the investigation anyways? That's a little bit difficult to unpack, but basically at the very beginning, before an investigation is opened, once the competent authority or the Commission approaches an economic operator, if they can show that remediation has happened, then they should be excluded from the investigation. And I believe our time is probably up now. Is that right, Valentina?
Yes, thank you both very much, Stuart and Johannes, and especially you, Johannes, again for making the time and for joining us also from the other side of the world today. So thank you so much. Now we're gonna continue answering some of the questions in writing, and in the meantime, if we could move on to the next part of the webinar, and I would like to welcome my colleague Jonathan Torngreen from Amfori, sustainability expert, who will set the scene a little bit about the Amfori's work in this space, and then we're gonna hand over to Caroline from Zwilling.
Yes, thank you very much, Valentina. So yeah, briefly to set the scene, at Amfori, we are a business association, and we support our members in their due diligence efforts. And we do so primarily via our sustainability platform, where our members can access our 2 primary products, which are Amfori BEPI, which is our environmental initiative, and Amfori BSCI, which is our social/human rights initiative. Obviously, today we'll be spending more on the social side as we're talking about forced labor. And so I briefly wanted to introduce you to our code of conduct, which covers 13 distinct performance areas. And obviously, one of the core performance areas there is on forced labor. It's our 11th performance area. And yeah, briefly to talk about this, what we see in reality is cases on forced labor are typically linked to passport retention, inhumane treatment, but more often than not, it is linked to the recruitment fees paid by workers. Obviously, as Valentina already alluded to in the beginning of this webinar, recruitment fees can, of course, lead to a situation of debt bondage, and that's what we try then to tackle. I think we can move on to the next slide, which is indeed on this performance area on forced labor. Not going to spend too much time here. I think I already listed kind of the main triggers that we see for forced labor. But yeah, maybe we can, I can pass it on to my colleague Alessandra, who briefly can talk to us about training available for those of you who are interested in a bit of a deep dive on the subject.
Thank you, Jonathan. Yes, so as the capacity building chapter lead for Amfori, I just wanted to take this opportunity to also raise awareness of some of the training that we are offering as Amfori. So especially, so we have a few ones, but the one that is most relevant here is the one on ethical recruitment that we have developed in partnership with IOM. So it's available online, either to register to attend or as a webinar recording. It's in English, and the goal is really to equip your company to understand better ethical recruitment and enable the companies to align their practices with IRIS standard. And hopefully the training is also aiming to help companies to create the policies, to identify the gaps in the recruitment process, and to enable them to prioritize risk and develop the right action plans in order to have better practices and monitor cases of forced labor in their supply chains. This is just a quick overview. Please feel free to register. There's a link there, but there's a couple of others. And if you want more information, please contact us after the webinar, and I'll be happy to direct you as needed. And with that, I just hand over back to you, Jonathan.
Yes, thank you, Alessandra. Yes, and then what we wanted to talk about now is our kind of rapid alert system. We call it, we call it a zero tolerance protocol. And for forced labor, as I mentioned, primarily this is related to recruitment fees. But just to explain to you how this works, this is the zero tolerance is triggered during a BSCI audit. So the auditor, when deeming that there is indeed enough evidence to warrant triggering the zero tolerance, they will activate this, and from our platform then there's a notification that goes to all the members that are linked to a specific business partner, and also this is going to Amfori, and we try our utmost to organize a call with all the linked members on this specific case, typically within 48 working hours. And there we try to then facilitate the remediation process together with our members, and hope to make advances and come to an alignment on how to tackle the case collectively with the business partner. Yes, then because we're going to talk about recruitment fees, I think it's also good to highlight that we mainly see recruitment fee cases in 3 locations: Malaysia, Taiwan, and Thailand. Each location has its specific challenges, but I think that yeah, we don't really have time to go into all these specific challenges. But our next intervention, coming from Caroline Knosper from the Zwilling group, is going to talk about a case related to Thailand, and so hopefully there we will have a little bit more of a deep dive on a country-specific situation. So yeah, thank you very much for joining us, Caroline, and the floor is yours.
Thank you very much, Jonathan, for the introduction. Good morning, everyone, and I'm glad to be here today to give you practical insights into our work at Zwilling. My name is Caroline Knospe, and at Zwilling, I am responsible for managing due diligence with our suppliers and driving purposeful, sustainable projects. Last year, a couple of more sentences. Last year, we led a forced labor case on recruitment fees with our Thai supplier. And in the next couple of minutes, I'd like to share with you how we solved the case. Before we now deal with the case, I'd like to give you a short introduction to the company. Zwilling was founded more than 290 years ago in Zwilling, Germany, and we offer high-quality products for modern kitchens, as for example, knives, cookware, also vacuum storage, all lots of products for tableware. The company is 100%, please back again. The company is 100% subsidiary of the family-run Wilhelm Wehrhahn KG and forms part of their consumer goods division. And last year, we achieved a turnover of 830 million euro and employ about 4,000 employees worldwide. On the bottom of the slide, you also see a selection of the brands belonging to our group. And to call out just two examples, the first logo shows our main premium brand, and De Meijere is stainless steel cookware made in Belgium. And it's also the Zwilling subsidiary with the highest dependency on the supplier that we will deal with today in the case. And this now already leads us right into the case summary. So what happened? A regular BCI audit showed that the supplier in Thailand passes on cost of mandatory work documents to its migrant workers from Myanmar. This could be cost, for example, for visa, but also passport or work permit fees. And they are also called recruiting fees. So for workers, this meant that they actually started their employment owing the company more than 1 month's salary, or when they had to renew papers over time, they had less money available to make a living. Now you're probably wondering, what is the compliance situation like? And I can tell you it's not that easy because it's not a violation of Thai law, but it contradicts with the BCI Code of Conduct as just introduced by Jonathan, which says that the employer is obligated to make sure that no recruitment fees and costs are charged to workers. And as also Valentina mentioned before and emphasized in the introduction, migrant workers have a relatively high risk of being affected by forced labor, so they can be considered as a vulnerable group. And this practice therefore puts them into a serious financial place. And as Amfori member, but also in favor of the employees, we stood up for this higher standard. Let me give you some additional information on the supplier. Zwilling and the supplier have a long-term business relationship and both are strategically important to one another. The factory is located in Thailand and produces handles for our De Meijere cookware. So as you can imagine, it's quite hard to use pots without the matching handles. The factory employs about 150 people, whereof about 1/3 is from Thailand. And 2/3 are originally from Myanmar, so they are Burmese. From the beginning on, we faced two main challenges. On one hand, the supplier suffered a weak financial situation. And on the other hand, they mostly serve domestic customers, and therefore they have little awareness about sustainability. Now we switch to the next slide. And there we see that we review the improvement journey now on the next slides in 3 steps. So first of all, we focus on the pre-improvement phase, afterwards on the improvement phase and post-improvement phase. And overall, the remediation took us about a year. Let's begin with the pre-improvement phase, and it shows the steps and the first actions we took to understand, but also to underline on the case. So shortly after receiving the zero tolerance alert, we aligned with Amfori, and there we also learned that we are the only linked member to work with the supplier. Thus, we gathered all Zwilling stakeholders and set up a meeting with the supplier for official remediation kickoff. And in this call, we also highlighted the seriousness of the situation. Next, we built a project team, and on supplier side, it consisted of HR, quality, and sales. And on Zwilling side, it involved the responsible buyer from De Meire, who has extensive knowledge on the overall business relationship. Furthermore, purchasing headquarter in order to lead the case, and legal in this case was very helpful to argue in favor of compliance. Next necessary step on the journey was clarifying the situation and reaching a common understanding. So we tried to get a clear picture of what was going on in the factory and how the factory especially recruits workers. And this brought up questions like, what does the recruitment process look like, but also is there any labor agency involved or not? Especially in this step, I can tell you, we experienced that the language barrier took us quite some time and effort. But after all, we managed to have a joint understanding, and it was also very important to align on the why we are doing the improvement work. Next slide, please. Next, here on the slide, we will focus on the main improvement phase, which is all about remediation. So firstly, the supplier participated in an Amfori training, and thereby they gained knowledge on responsible recruitment and also learned how to drive changes in occupational health and safety. Secondly, we set up meetings with the supplier every 2 weeks. And during these calls, we deep dived into improvement actions. We spoke about the progress, but also we focused on questions, difficulties, or supplier concerns which came up. Moreover, we intensified the collaboration by visiting the factory. And this strengthened relationship, but also gave us the chance to see the grievance mechanism in the factory. Over the months, we also checked in with Amfori on the progress, and their experts supported us where needed. Now let's have a look at the third column, which is all about the reimbursement. And I can tell you by far, this was the most resource-intense exercise of all of them. First of all, we had to clarify the requirements, with the result that fees had to be reimbursed for all employees that still were with the company, but back to 2019, because this is when the ILO conventions set in. Next step was getting an overview of actual payments made by migrant workers. So we created an Excel template to get the overview and some transparency. And the supplier then investigated on-site with a team which fees were charged from which workers to what time and for which purpose. And therefore, they also reviewed passports and the interviewed workers, and at the end, of course, documented it in the template for transparency reason. So now, as a result, we had a filled template. However, charged fees, which were in the template, were quite individually, and we couldn't really see a pattern. So we asked ourselves how reliable the data actually is. And hence we checked for plausibility, but we also shared the reimbursement plan with Amfori for a second review. Besides creating the template, coming to a final agreement on the overall deal was by far the most difficult task, because especially due to the lack of suppliers' management commitment, but also due to their overall weak financial situation. At the end, it required conversations between both managements, digitally and in person, to overcome the obstacles. And it's also clear to say that the overall agreement was built on the strong and trustful business relationship that both companies already had in the last couple of years. In parallel, we adjusted their company policies. So we added one paragraph, which was about the reimbursement, and another one that made sure that the factory will cover all recruitment-related costs in future. Last but not least, the supplier communicated changes to their employees, making sure that they are aware of their benefits. And they even received a document each that summarized the open sum of reimbursement, and it got signed by both parties at the end, also being good proof for the auditor to see. Now here on the slide, you can finally see the post-improvement phase and how we verified the effectiveness of taken measures, and we closed the case. By the time, we can say that about 8 months had passed, and to make the reimbursement work with suppliers' cash flow, which was an issue, we scheduled the follow-up audit for April, because by then the factory had, first of all documents in place. Secondly, the first 50% of reimbursement were paid back to the workers. So one part covered by the supplier and the other part covered by De Meyer. So we contributed financially. And for the second 50%, the first of overall 36 installments was also paid, so the auditor could see that it's running well. Following Amfori's recommendation, we also briefed the auditing company on our past improvement work before they visited the factory. Now you're probably wondering, what was the outcome out of all this effort? And I can tell you, when the audit results became available, we were quite happy and relieved. The report confirmed a successful implementation of the actions. Forced labor findings were solved, and the factory could significantly increase their social performance. So forced labor and occupational health and safety rose from an E to an A rating, and overall they were able to achieve a B rating. So through the past journey, the supplier now has profound knowledge on responsible recruitment and is aware of social compliance. And additionally, from my perspective, continuous improvement is what matters the most. For the workers, we jointly achieved that they will be reimbursed 44,000 euros in total, and from now on, the factory will cover recruitment-related fees. Outcome for Zwilling, especially, is increased awareness on the recruitment fee topic to cover it all over the supply chain, and we gained experience in handling a serious case. And most importantly, we now have a strong ESG supplier to work with in future. Final step on the improvement journey was then going back to normal. So Amfori released the zero tolerance alert, and internally we transferred the supplier to the regular BCI circle with the next audit in 2025 and regular continuous improvement work. To make sure the ongoing installments run as planned, and we also had to involve the responsible buyer, who just checks in with supplier from time to time in their regular calls. And overall, the installments are planned to be completed by November 2026. Next slide, please. So in the last couple of minutes, you've learned that we faced several challenges, and to overcome them, we identified 3 main key success factors. To begin with, I'd like to point out the need of mutual strategic relevance and a long-term business relationship. So both companies need to have the interest to continue business in future and need to look into the same direction. In addition, cross-functional collaboration and management commitment is crucial, because if the supplier's management commitment is missing, this is definitely where to start. Because as soon as you have the management support, the entire process will run much smoother. Moreover, in our case, delivered result very often were not as planned, and also ongoingly new supplier concerns came up, so we had to take care of them. And thereby you can also say that through the entire journey, an ongoing open communication on eye level, but also together with some optimism, patience and persistence is definitely what are key success factors, and they help to solve the case and bring it to a successful ending for the workers, for the supplier, but also for you as a company. Next and final slide. So overall, I hope that the presentation could give you good insights in how to manage the forced labor case on recruitment fees. I thank you very much for your attention, and I'm glad to open any open questions either via the FAQ or you can reach me via LinkedIn after the session. Thank you very much.
Thank you so much, Caroline, for your willingness to share how Zwilling went about dealing with a case of recruitment fees detected through the Amfori BSCI system. Now I would like to give the floor to Melina Kunde for also her part of the presentation about the PST approach. And then we're going to try and go into Q&A, and in the meantime, maybe also answer some questions in writing. Thank you, Melina, over to you.
Thanks a lot, Valentina, and hello, everyone. My name is Melina Kunde. I work as a project manager at the Secretariat of the Partnership for Sustainable Textiles, which is a multi-stakeholder initiative for human rights and environmental protection in textile supply chains. The Partnership for Sustainable Textiles was founded 10 years ago and currently entails 120 members from different stakeholder groups, being businesses and associations, standards organizations, unions, non-governmental organizations, and the German federal government. And all these members unite in order to act collectively for healthy environment and social justice in textiles. Next slide, please. I'll try to keep it short in order to have time for the Q&A. What I've brought today is an overview of what we do at the Partnership for Sustainable Textiles and how we work on certain topics in order to specifically enable and support companies in their due diligence processes. And therefore, we have a first core element, as we call it, that is being called implementing due diligence, and their member companies report publicly every 2 years on how they fulfill their due diligence obligations. I'll come to that in a minute, a bit more in detail. And the second core element is called supply chain transparency, and encompasses that member companies map their suppliers and actively contribute to more transparency in textile supply chains. While we collaborate with the Open Supply Hub, this industry-wide solution is being supported in order to enhance the data publicly available. And within the third core element, we aim at addressing so-called focus topics. These are listed below, being living wages and purchasing practices, circular economy and climate protection, gender equality, and grievance mechanisms and remedy. And within these focus topics, we have a lot of support for companies and mechanisms for different stakeholders to get together and in order for companies to make progresses in these focus topics. And a very special case is something that we call joint actions, being projects that are being implemented by a group of members in a multi-stakeholder context in order to achieve these goals mentioned in the focus topics. As being said, I will look a bit more detailed into the first core element, being implementing due diligence, where we've established a process for companies to go through, let us call it maybe a guided risk analysis at hand of the 11 sector risks, where companies first analyze and prioritize risks, targets, and report on the progress of these targets, which is then being assessed in in-person meetings, adjusted, and then published on the website in order to be openly available. Next slide, please. Thank you. In order to support companies in their process, there are some preventative actions that we try and establish in the PST, being, for example, guiding and supporting materials. You see some of them here. Most of them can be downloaded on the website, for example, in case you want to look deeper into it. And another very important pillar of this multi-stakeholder initiative is definitely what we call learning through dialogue. So it is working, we have certain working groups on relevant topics, for example, webinars on trainings on the topics, and we aim at enhancing peer learning in the joint project implementation. And when it comes to the projects, there will also be another slide later on. So we'll just continue. Thank you. When it comes to remedial actions, the PST has decided not to operate its own cross-company grievance mechanism in order not to add to the current fragmented system of different channels. Instead, the PST engages in exchanges with other organizations, for example, Fairware, Amfori, FLA, ETI, and more, as mentioned here on the slide, in order to identify synergies and potentials for harmonizations. Furthermore, the PST offers its members the use of the Fairware grievance mechanism and works together specifically with Fairware and Amfori on complaints and shared factories. And overall, the PST supports and encourages members to join forces by implementing joint grievance mechanisms in shared production facilities. And on the next slide, we'll see an overview of the projects that I mentioned that are currently running in the different focus topics. So the projects range from, for example, peer learning and efforts when it comes to living wages, go on designing circular collections in a project on the topic of circular economy. And for example, in the end, you see 3 projects on grievance mechanisms. You can go to the next slide, as I will just keep it as brief as that. In case you want to hear more details or want to get into discussion, have questions, please feel free to reach out. And we try to adhere now to as many questions in the Q&A as we can for the time being. And I see when I look at the questions being asked that there are a lot of questions to you or being asked directly to you, Caroline. And first of all, many people thank you for being so open and sharing this case. Maybe you could start with, if you want to, and feel free to let us know what and how much information you can share. But are you able to share how the reimbursements were calculated and or defined?
Yes. So first of all, this was the task done by the factory, but we had one of our inspectors there to accompany the entire process to make sure everything was okay. So the workers were interviewed and also passports were checked. And then in our reimbursement template, we had a list where each worker was mentioned by a number with the years they were already working for the factory, because this is also the indicator how many fees and there have been. And then for all the years, it was written down, which fees were paid based on the interviews, but also on what was available in the passports. So if there's anyone who has individual questions and would like to catch up with me later, I'm very happy to share our approach, also showing the template.
Thanks a lot, Caroline. Then maybe a question directed at you and or Jonathan, maybe looking at the Amfori colleagues. Maybe you can tell us if this process was, or the steps that you mentioned, was made up by Zwilling, or is that something that is has been done with Amfori support?
Maybe I can start answering. Jonathan, you can add.
Yeah.
The process was set up by us, but following a very pragmatic angle. So we said, okay, getting together with the supplier first for an official kickoff is important because this stresses the seriousness of the situation. Of course, there were also parts that included Amfori. So we checked in with them many times, and also the kickoff call in the beginning was very important to align. And yeah, we would have loved to remediate the case with other members involved, but unluckily we were the only member connected. So we took the challenge, and yeah, I'm glad we managed fine. It was a lot of efforts, to be honest, but I'm also thankful for the experience.
Yeah, and just to add to this, I think it's really is key to have that first conversation with the supplier, because that really defines your remediation process. And as Caroline said, yes, there might be an internal alignment prior to reaching out to the supplier if there are several members linked to them, and there you can already define a little bit the steps to be taken. And you obviously have more leverage in such a situation. But I think in this particular case, it makes a lot of sense to have that initial conversation with the supplier to define the process.
Thank you, Caroline and Jonathan. Jonathan, maybe when already talking about processes at Amfori or the Amfori support, there was a question on if there's any specific recruitment fee calculator that is recommended by Amfori BSCI.
Sorry, could you maybe like go into a bit more detail, because it's a very general question.
It rather is. Maybe directing at the person who asked the question, if you could elaborate a bit more on that. And Jonathan, we could also take up another question that you could maybe shed a bit light on the difference between Amfori, BPI and BSCI, and the HIC, FSML and FEM. Is that possible?
So I'm really a sustainability expert on the social side, so HIC is not really what I'm an expert on. But for the difference between BSCI and BPI, I should be able to cover. So obviously, in BPI, we focus on environmental performance areas and such as waste management and so forth. Whereas with BSCI, the focus is solely on the conditions for the workers. And no, there is a small environmental aspect involved in the BSCI Code of Conduct as well, but the primary focus is on the workers.
Thank you, Jonathan. Then there's another question on the subscription. Sorry, is there a dual subscription that you need to have on Amfori for the business partner and Amfori member, or is it possible to only be Amfori member and still be a business partner to customers?
Yeah, indeed. That is indeed the reality that we see. We have a lot of members that supply to end customers who might also be Amfori members. So in this case, yeah, they might qualify as business partners technically, but they're not the ones that are audited, but they would audit their suppliers who are in the supply chain of their buyers.
Thanks a lot, Jonathan. Caroline, looking at you, maybe, there is another question. What if the supplier rejected to take further action? What kind of actions would Amfori and brands take? Maybe, Caroline, you can start, and Jonathan, if you would like to add from the Amfori perspective, feel free.
Yeah, I think first of all, dialogue is key. So you need to have lots of conversations with the supplier, and of course also purchasing power is one important element to consider. If this is very low, it's definitely a challenge. In our case, it was also very helpful to have the responsible buyer involved, who has very close interaction with the supplier and daily business and knows the overall business situation. So he could very often communicate with the supplier and also to set it in the overall context of the business relationship, which was helpful. To be honest, if management commitment is not available, this is an issue. So in case we couldn't have managed to get the management commitment, solving the case would be very hard, because at the end it comes down to financial issues, and this needs to be approved by the management. So ending a business relationship is last step. So we would do everything before we need to do that, because this is just how you can drive changes. But yeah, at the end, this would be the final thing to do when it doesn't work out after a lot of effort has been paid into it.
Yeah, indeed. I think dialogue is key, and again, it depends on the situation. If there's a lot of leverage, then you can affect more pressure. But that being said, in many cases, there are other players involved as well, such as recruitment agencies and so forth. So it can become a very complicated topic, and one that needs careful conversations.
Thanks a lot to both of you. And I see more thank yous, especially to you coming in, Caroline, for being so open and talking about this case and the good practice that you're sharing here. There is one question that I would answer myself, as it was directly directed at the Partnership for Sustainable Textiles. That's okay, and that was on the peer learning. I would say, or it was more in detail on how how the peer learning is being supported, basically. And I would say it is, or we perceive it as the nature of an MSI and our heart to bring different actors together and to work collectively on the topics that are pressing. We do that in, for example, in-person events, but also establishing the collaboration and exchange among the different stakeholder groups in the projects mentioned in an internal platform where discussions on certain topics can occur. So something that is very important to us. We're still trying to improve always, but see that it is also getting better over time. On that note, as there is not much time being left in this webinar, I think we are still all being busy trying to answer as many questions in writing as possible. Valentina already mentioned it in the beginning. We're sorry that we cannot address all the questions that you posed. These are very interesting and very relevant questions to the topic. So thank you all for your participation and for your active engagement, especially here in the Q&A. A special thanks to all the speakers that have been here in the call. I, for myself, have learned a lot, and I hope you all did as well. So thanks, Johannes, Stuart, Alessandra, Jonathan, and Caroline. And a special thanks also to Valentina and Else, who have made the organization and this whole webinar running so smoothly. Valentina mentioned in the beginning, this webinar was part of a series. There are not yet any other dates or topics set, but please keep an eye out, especially on the Amfori, but also on the PST website for more webinars, for more guidelines, learning materials, and events. And here you find a QR code where you can share your feedback that we value a lot, of course, as we aim at getting better always and adhering you to your needs. So thanks a lot. Have a great day and see you soon.
Thank you very much. Take care.
Goodbye.